Since yesterday, we are requesting the learned counsel to have the address of Sherlock Holmes. Because I don't have. If there is any other alternative for the lawyers, have an investigator to get your files. Item number
19, Lordship.
19.
Yes.
Okay. Adjourn on the, all sides are represented. Adjourn on the prayer made by learned counsel for the petitioner. List after a week.
Obliged, Lordship.
May I please, Your Lordship? The English Council, Mr. Yami Mahmood, Your Lordship, he is on leave, Your Lordship. So item number 4 and 36, Your Lordship. So time may be given.
Item 4 and 36.
Yes, ma'am. I mean,
All sides are represented. The prayer made by learned counsel for the petitioner. Okay. List after a week. Okay.
mass of us.
May it please, Lordship. Lordship, item number 16, may kindly be adjourned for the day.
Why?
The conducting counsel is suffering from illness.
In 2017 matter, you are taking adjournment.
Yes, only for the day, Your Lordship.
No, every time your matters can't be listed. Just let me see this item 16. How many adjournments you have taken? Let us see. After some time, let me examine how many adjournments you have taken. Yes.
Please, Your Lordship, I beg to mention item number 3. Lordship may not like to take up the matter.
3.
3, yes, Lordship.
Okay.
And,
List for another bench without
and Lordship.
one of us. Yeah, Surangaji.
And in item number 6 also, appearing counsel, Lordship may not like to take up the matter.
Item 6.
Yes, also, Lordship.
Why?
Appearing counsel or appearing counsel, Lordship, who argued the matter
Okay.
earlier.
Okay. 6. Same order.
Deeply obliged, Lordship.
May I please, Your Lordship? Lordship, I beg to mention item 15, Lordship. Kindly adjourn this matter.
15. Okay. Adjournment of the prayer made by learned counsel for the petitioner. List after a week. You just say list after a week as paid for by learned counsel for the petitioner.
Obliged.
Yeah, please, Your Lordship. I beg to mention item number 17, my Lordship.
Item
17. Let it come after 2 weeks, my Lordship. As the learned
17.
counsel- Yes, my Lordship.
Let me examine. How many adjournments you have taken earlier? So, we should have an answer. In item 17,
Yes, sir.
Who's the arguing counsel here?
SAM.
Where is he?
It's out of station only. It is some personal issues.
Okay. List after week as paid for by learned counsel for the petitioner. We take note of the fact that despite opportunity granted to the petitioner to bring additional to bring additional relevant material on record, no additional documents have been filed. Next paragraph. List after 2 weeks or 1 week. List after a week. Okay. There was a prayer for adjournment on item 16. We allow that. 16 was a prayer made there. List after a week. Yes.
Yep.
May I please, Your Lordship? Your Lordship, with the consent from the other side, I beg to mention item number 38. Conducting senior counsel is out of station, Your Lordship. Matter may be listed after 1 week.
No, these are review matters. Why you need an adjournment of so long? 23 matter.
My lord, in this case, we are for the respondent bank. Until date review copy has not been received. A copy of the review petition we have not received, my lord.
You're not received.
No, my lord.
You never demanded. You know who's in the other side. You could have requested them. And you are aware that these prayers are not entertained by this bench.
Last order also, my lord, it was reflected that a copy may be served.
It's not served.
Not served.
Then we dismiss your writ petition. If you don't serve copies.
Your Lordship, I have to take instruction.
I don't know, we give you 24 hours. You go to their home and serve it. If not, after 24 hours, this review petition will be dismissed without reference to the court. Just show me the record, file 24, 38. Okay, next item in the meanwhile.
You just wait, just wait.
Don't go.
May I please, Your Lordship? Lordship, I beg to mention for listing of two items for
Give it to the court master.
Oblige, Your Lordship. May I please, Your Lordship? I would like to mention item number 11. Can the matter can be taken up for next day?
Motion matter. List after 2 weeks as paid for by non-counsel for the petitioner.
May I please, Your Lordship? I would like to mention item number 25 of daily leave. Lordship, my senior is suffering a cold fever. He is under treatment, undergoing treatment. Lordship, kindly matter pass over for the day.
List after 2 weeks as paid for by non-counsel for the petitioner.
Even the same order is there.
In this review matter, item 38. Also, as a represented, therefore adjournment is made by the learned counsel for the petitioner. Next paragraph. The learned counsel for the respondents has referred to the order dated 8/2/2023 and has submitted that the copy of review petition has still not been provided to them. Next paragraph. We provide that we direct the learned counsel for the respondent, sorry, petitioner, to ensure that the copy of this review petition is served on the learned counsel for the respondents within 7 p.m. today, failing which the petitioner shall be doing so at on failure to furnish a copy. You would presume that the petitioner is not interested to pursue the matter, and and adverse orders would follow on the next date of listing. Next para, list on first. Give date after a week. On which date no prayer for adjournment shall be entertained on behalf of the petitioner. 7 o'clock today, otherwise it will be dismissed.
Obliged.
You take her address. Does you have to go and serve? Take her address.
Obliged.
Daily list item 1 for motion.
Your Lordship.
Yes.
Lordship, this is a matter of 2018, Your Lordship. Your Lordship, unfortunately, Your Lordship, this matter came up once, Your Lordship, but LCR was not yet called. And Your Lordship, because Your Lordship, I have also contact with the client, and they have also failed to contact me in the last 5-6 years. So this matter has been pending in such a way, Your Lordship. Your Lordship, but from the brief, it seems, Your Lordship, the petitioner in this case,
But the requirement of the order was to file an affidavit to,
Your Lordship, I have filed an affidavit, Your Lordship, to rectify the date.
you filed.
Yes, Your Lordship.
When? It's not here.
Which copy is with me, Your Lordship?
Office note says.
Oh, it has been received. No affidavit has been received.
No affidavit. No affidavit has been, when did you file it?
Lordship, I have got the office copy, Your Lordship, I have to check it, but I have got the office copy, Your Lordship.
You verify from the registry.
Verify from the registry, because otherwise
Your Lordship.
you take a risk. 2018 matter. We had made by Mr. I. Hussain, counsel for the petitioner, list after weeks, so as to enable him to ascertain as to whether the order dated 26/11/2018 has been complied with. Any learned counsel who wants
Item
to
2.
rely on any citation, please give it in advance. Otherwise, those matters would be adjourned. Give the list, book list to the court master in advance.
Lordship, petitioner was declared as a foreigner, my lord. Petitioner's father's name recorded in the Bhuta list 1971. my lord.
Item 2.
That is page 12, my lord, annexure 1. Thereafter, my lord, after the attending majority, my lord, petitioner was married some other persons, my lord, and one GP
No, no,
certificate
but you
also-
see, we can't entertain a petition now with the nature of prayer you are making. In 2010, you were directed to get yourself registered.
my lord.
You can't take a plea that I am a poor beggar woman. When we see you, we know it is a proof that she is not a beggar woman.
My lord. At the time of filing, my lord.
She will not be able to afford you.
My lord, she is very poor, my lord.
No,
No
no.
other person is looking after my lord.
Hard to believe when you are there. Yes, Mr. Pai and Mr. Sharma. She is declared to be a foreigner of 66 to 71 stream.
Yes.
So she has to be registered. If she registers now, again 10 years lock-in period. So what do you say?
Well, the law provides that she has to register within 180 days. Law provides she has to register within 180 days from her declaration. 2009 rules, my lord. The foreigners law.
Have you taken the petitioner into custody? No.
Not in custody, my lord. Custody. Not in custody, my lord.
What is the consequence of non-registration within time?
She's a foreigner, my lord. Even though registered, she is a foreigner. My lord. She has to register as a foreigner, my lord. The direction itself.
No, no. Brother is asking what is the consequences of not being registered? Not registering herself, what is the consequence? He's a foreigner, we understand,
Yes, ma'am.
but she came in 66, 71 stream.
Yes.
So what is the consequence of not?
If she is not registered, she will have to be reported, that is.
Where is the provision for registration?
Registration, my lord, did citizenship and 6A. Citizenship Act 6A, my lord. 6A 2, my lord, 6A2. Six A2 of the Citizenship Act, man. Subject to the provision of subsection 6 and 7, all persons of Indian origin who come before 1st January 1966 from Assam specific territory, including whose names were included in the electoral rules, general election of so and so, who have been ordinary resident of, shall be deemed to be citizen of India from 1st January 1966. Then, my lord, 6A3, my lord, that is the specific subject to the provision of sections 6 and 7. Every person of Indian origin who come to Assam on or after 1st January 1966 and but before 25th of day of March 1971 from the specific territory and has since the date of his entry into Assam been ordinary resident of Assam and has been detected to be a foreigner shall register himself in accordance with the rules made under the central government's on behalf of the section under section 18 with such authority and may be specified in such rules if his name is included in any electoral rule for assembly or parliamentary constitution in force of the date of detention. His name shall be deleted therefrom. Explanation. In case every person seeking registration under this subsection, the opinion of the tribunal constituted under the Foreigners Order 1964, holding such person to be foreigner shall be deemed to have sufficient proof of requirement under sections clause C of subsection if any question arises as to whether such persons complies with other requirement under subsection. The registering authority shall, if such opinion contains finding with respect to such other requirement, decide the question in conformity with finding in such a
No, where is the, is there a rule framed?
yes, man. Rule 2009 rule is there, man. The same book. If it is your lordship of holding this book, man.
Yes.
Okay, this.
Citizenship rules.
Yes, citizenship rule 2009, man.
Rule number?
Rule My lord, 19, my lord.
19.
But there's no consequence. What happens thereafter? Neither there is a negative provision that thereafter he can't be registered.
My lord, your lordship will find, my lord, 19.2. 19.2 and 2.1, my lord. 2A, my lord. 2 says when he can be registered. An application for registration under subsection 3 of section 6 will be made form number so and so by the person registering authority for the district in which such person is ordinary resident within a period of 30 days, specific days, my lord, from the date of receipt of order of foreigners tribunal declaring such person as foreigner. Provided that registering authority may, for reasons to be recorded in writing, extend the said period to such further period as may be justified in each case, but not exceeding 60 days. That is in case of if by the registry. Number 2, my lord, 2A. A person who has been declared to be foreigner by the Foreigners Tribunal prior to 16 July 2013. My lord, there was a case in 2013, and there was a direction, and on the basis of that, this amendment was made, my lord, prior to 16 July 2013, and has not been registered under subsection 3 of 6A for the reasons on non-receipt of the orders of Foreigners Tribunal or refusal by the registering authority to register such person as foreigner on account of delay, may, within a period of 30 days from the date of receipt of the order passed by the Foreigners Tribunal or from the date of publication of this notification, make an application for registration in the form number so and so to the registering authority of the district in which such person is ordinarily a resident, provided that the registering authority may, for reasons to be recorded in writing, extend the said period to such further period as may be justified in each case, but not exceeding 180 days. So that was a special case, my lord, where the persons who did not receive the certified copy, they were given a special, my lord, privilege to apply within 180 days from the date of receipt of this, my lord.
Now, in this case, deliberately there was no registration.
Yes.
What is the consequence?
Consequence, my lord, she will be treated as foreigner. What the consequence normal foreigner will suffer, that has to be suffered by her. Because detection is foreigner. She entered in 6671. Then it was, if she registered, my lord, then she will have been given the offers, my lord, benefit under 6C. But to get the 6A, she did not register 6A clause 3, my lord.
You were declared a foreigner, sorry. You were declared a foreigner. You were directed to register.
My lord,
You were directed to register, you did not register.
no,
So the fact remains that today you are a foreigner. Assuming we examine this matter.
my lord, one opportunity may be given for
No, we'll
registration.
have to examine it. You are challenging the opinion of the tribunal. So we'll examine this matter. But while we are examining, what is your status? You're a foreigner. You cannot be allowed to move about. You'll have to be detained till we decide the matter. The law, the act and the section is very clear, 180 days.
My lord, as per order, my lord, petitioner was declared a post 1966, my lord.
Yes, but you were supposed to register, you did not register.
My lord, petitioner is extremely poor, my lord. And
Whatever it may be, whatever it may be, but the mandate of the act is that you must do it within 180 days.
What is
My
the
lord-
registration fees if you are poor? Just let me ask you. What is the fee charged by the Union of India?
My lord, she is a illiterate, my lord.
No,
that
that's
is the
okay.
problem, my lord.
Everything is okay.
My lord.
And how much fees does the government of India charge to have you registered?
No, sir.
No charge.
My lord, actual problem is that, my lord, no other family members.
No,
is
no,
look
I
after
know
him, my
extremely
lord.
poor.
Her husband also
No,
expired, my lord.
we are not questioning that she is extremely poor. I think the government is registering her for free. But you can't say that you don't know you are extremely poor, you are illiterate. Those things won't come in. And there are two issues again. Number one, there are various decisions of this court as well as of the Supreme Court saying that when the statute prescribes a time limit, then section 29 of the Limitation Act applies and the court cannot extend time. There's not one, such decisions are there for many issues where limitations are prescribed. Therefore, you can't extend the limitations. Question of issuing a fresh direction for a registration of you as a foreigner for between 66-71 stream will not come. We can't give you bail. There's the second issue. Once we can't suspend the order, we can't grant you bail. So the only alternative is to put you into detention. You have to appear before the SP and you'll be taken into custody.
My lord, matter may be remanded back to this foreigner tribunal, my lord.
No, question of remand will not come because of the fact that one part of the order has attained finality.
My lord.
Asking you to register, that has attained finality. You have not done. You have to show us that we can turn the clock back. That's one part. There's a second part we said that if you examine the matter, you must be taken into custody. You can't be a free citizen. You have to surrender and you'll be taken into custody. So that takes care of your poor status. You don't have to beg now.
My lord, without bail, my lord, petitioner.
But now you don't have to beg. You said that you are a beggar lady. Now you don't have to beg. You will have a dignified living. You'll have to surrender while we examine we call this record of the tribunal. But Ms. Al-Wazira, learned counsel for the petitioner, Mr. J. Pang, learned along with Mr. G. Sharma, Learned Standing Counsel for the Home Department, and Ms. A. Gayan, Learned CEC, and SK Haloi, Learned Hazarika, Learned Government Advocate appearing for respondent for Deputy Commissioner for respondent 4. By filing this petition under Article 226 of the Constitution of India, the petitioner has assailed the order dated. So opinion dated 7/4/2010, passed by the Foreigners Tribunal Hojai in FT space H space case number 209 of 2008. Next, the case of the petitioner is that despite the direction contained in the said opinion that the petitioner was a foreigner and had entered in the state of Assam between from erstwhile East Pakistan between 1/1/1966 to 25/3/1971, and the direction the petitioner did not register herself before the FRRO Hojai,
Is it Hojai or Nogam?
Nagaon, within the time prescribed. Under Rule 6A of the Citizenship Rules, 2009. Full stop. Next, the petitioner has also asserted the impugn opinion on merit. Next, paragraph. The Learned Standing Counsel for the Home Department has submitted that as per the provisions of the Citizenship Act, 1955 and the Citizenship Rules, 2009, there is no provision permitting extension of time beyond 180 days for registration of a foreigner who had entered into the state of Assam from erstwhile East Pakistan between 1/1/1966 to 25/3/1971. Next one. We also oppose the admission of the writ petition after a lapse of 14 years from the date of opinion. Next paragraph, as it may. Notice returnable on give a date after 5 weeks. Also, so requisite extra copies of the petition will be served on the under state and departmental counsel in course of the day. Within 2 days. Next, let the records of case number FT within bracket, oblique H oblique 209 oblique 2008. Called for from the Foreigners Tribunal, Hojai Shankar Dev Nagar. Next paragraph. Is the attention of the court is not drawn on any provision under the Citizenship Act 1955 or the Citizenship Rules, 2009 to permit the court to extend the time for registration of a foreigner at FRRO, Nagaon. The only option the court would have is to direct the petitioner to surrender before the Superintendent of Police border. Hojai, Shankar Dev Nagar. Till further orders of the court. For within a period of 15 days from today, within a period of 15 days from today, next para, list on so and so.
Item 5,
Also, in earlier occasion, one direction is given to take the present status in connection with the Orang PS case number 43 of 24. I have received yesterday,
Yes. You see, we don't appreciate this, what has been produced.
Yes, Lord.
You know what your Superintendent of Police has done? He'll tell you in a moment. You know what your Superintendent of Police has done? You read this and the earlier report.
Almost same notes.
So almost same. So what investigation he is doing? Outsource it. Give it to Google. If you can't find out a person, please ask your Superintendent of Police not to give a reproduction of the earlier letter. Earlier letter has paragraph 1 to 6. This letter also has paragraph 1 to 6. Same contents.
Only present is in status. of
Maybe
that
now
case
this time the
number.
clerk is different.
Only
So some language is changed. Some grammar is here and there.
and
So
it's
that means there's a new clerk in this office.
matter में pass over for timing.
No, this is a habeas corpus. We can't just adjourn it like that. Minor girl is missing.
Yes, Lord.
You, in the earlier letter, you said that we are making effort to track out the IMEI. At least you should have shown that we have done something to track that.
Okay, additional,
Because when you pass adverse orders, then you will go to the press and tell the court is doing this, the court is doing that. Because this is a fit case where we should ask your superintendent of police to undergo police training, investigation. He should know how to investigate. If he knows how to investigate, he'll ask his junior officers. He will teach them how to investigate. We are sending these two letters to your, who is the head of the Home Department? Additional Chief Secretary.
it is, it is Lordship Udalguri.
No, who is the head of the department home?
Commissioner and Secretary.
Commissioner and Secretary. So we are sending these two things to him to examine. If this is how habeas corpus petitions are dealt with the authorities. Can you get us better information by tomorrow?
Lordship, P. Sharma is dealing this matter. He is
No, we are not concerned who is dealing with the matter. You are here, that is good enough for us.
Monday, Lordship. Next Monday.
This is a habeas corpus.
Yes, Lordship.
Every
Minor
second,
girl.
every minute counts.
Even 15 years of old, young,
Hmm?
minor girl, 15 years. Minor.
No, because this man must go to the, go to a training school. We are taking the code very lightly.
Term is fixed for Monday, Lordship. I will try.
No, we take it up at 2 o'clock. We are, the video of the today's proceeding must be live by now. You request this Superintendent of Police, Udalguri, to look at the proceedings of item number
Five.
5 and tell us by what time he will provide better particulars. So at 2 o'clock, we'll take it up. Ask your Superintendent of Police to look at the video of the court proceedings now. And let him tell us what to do at 2 o'clock. We take the advantage of the court being live. Let him look into the proceedings. 2 o'clock, tell us.
Item 7,
Yes.
May I please lordship that contested case lordship. My name is Ansar Ali lordships. My father's name is Amezuddin lordships. In the order letter of 1966. Lordship, the page number 31 lordship. My brother was examined lordship as DW2 lordship.
But there is no link. The only link is the land document. The only link is the land document, that only revenue receipt. It can't be connected to any particular land.
Your lordships, my name is
is recorded my father's name against my name, Lordship.
But then you take a plea that your father died in 1966, your mother, what do you call, she died before 66. Father died after giving vote in 1970. How do you connect?
Lordship, my name is Ansar Ali, Lordship. My father's name is Ames, Lordship. In the 85 voter list of the onwards, Lordships. My brother was examined, Lordship.
Just a moment. Yes, where is the affidavit of your brother?
Brother, Lordships.
Where is your affidavit?
The Lordship, the type code Lordship 64, the DW2, my brother.
Which page? Which page?
Page 64, Lordship.
64.
Type code Lordship. The particular is 65, Lordship. Janegali, my brother, Lordship. Amish.
Where is the voter of both of you together?
Lordship 66 voter list is also.
Hmm?
Sorry, Lordship.
Where is the voter list showing you with your brother or any document showing that you two are brothers?
The Lordship's voter list not submitted, Lordships.
Hmm? Because if there is no document, it is only a self-declaration.
File additional affidavit, Lordship. So it's time, Lordship.
Where is that?
The voter list of my brother, Lordships.
Huh?
The voter list of my brother, DW2, Lordships.
Where is that?
There is no Lordships. The 2 weeks time, Lordship, I file additional affidavit.
No, you could kind of improve like that. If it is not there in the trial court, it's not there. In a writ court, to entertain additional document to which is not there in the tribunal is not permitted. There are a lot of decision which says that the self-declaration is not permissible. Mr. Ahmed, then we dismiss your writ petition.
Lordship, verify the record, Lordship. To what extent?
No. Mr.
The
Ahmed,
the document
you
submitted.
see, you are doing these matters for long. Therefore, you can't say that I do not know the procedure. You are making a challenge, correct? And then when you ask questions, you say that the documents are not there, you file additional documents. Why you are moving a half-hearted manner, these repetitions? If you want to take adjournment, take it in the first blush. Don't make us open the file.
Lordship, the another documents from the municipality lordship, the page 59 lordship,
Page 59.
the home Panchayati Raj lordship, on the license of on the polar card lordship. 59 lordship. Answer lordship,
Is issued in the year 1993.
1793.
33 lordship. My against my name, lordship, my father's name is recorded lordship in the 1985 portal, it's 1997 lordship.
Who came to exhibit this document? You see, these are no inquiry at all. This is a what you call challan for a thela.
Hello, lordship.
So you pay 10 rupees and you get a challan for a hand cart. Like when we were kids, in the cycle, there was requirement of having a GMC token of rupees 2 earlier, then it became 5. So that is not a proof of, that's not a proof of relationship.
My against my name, my father's name is recorded lordship, Damesh lordship. 97 voter list lordships. 85 lordship. This is the linkage lordship.
No, but who was examined to prove this?
Exhibit lordship. The
Huh, who
documents
was
are
examined? DW1 did not exhibit this.
the lordship, the
DW2 also did not exhibit this.
petitioner was exhibit lordships. Exhibit 3 lordships, 1985 voter list lordship. Exhibit 3 lordship, 97 lordship 4, exhibit number 4 lordship. 1997 lordship. Answerably, lordship, the father's Ames lordship. I claim that my father's name is the Ames lordship.
Ansar Ali.
Answerably, the petitioner lordship.
You are Ansar Ali.
Answerably lordship.
Huh.
Father's name is Ames.
Where is that exhibit? Page 60. I am reading page 60. I have read this page 61. Where is this exhibit marked? I'm not getting it.
This is the deposition lordship.
Huh?
Page 61 is the deposition of the Answerably lordship. Oral deposition.
So how do you prove it?
The village is different.
The lordship, and the documents are exhibited lordship.
But how? I'm reading your evidence.
Lordship.
How did you exhibit that without without anything stated in your evidence? Please tell us. Please show us how did you exhibit it?
Lordship, in this tribunal, Lordship, written evidence was not submitted
that's
and
okay.
not accepted by the.
No,
member.
that is okay, but oral evidence also you must introduce an exhibit. How did you show that exhibit?
The oral evidence only, Lordship, the written was not submitted
No,
and
that
not
is
accepted,
okay.
Lordship.
That is okay, we are not questioning that. How did you introduce the exhibits?
Lordship, base Lordship, 86, Lordship. There is marked the exhibit
Page?
68, Lordship. Middle portion, the exhibit 3. It is also another certificate copy of the electoral roll of the 1985 in residence of place Lordship technical under the Swans of Lordship. The border list there, the Lordship, the type of.
Yes, Mr. Shah, this is how this proceedings
sir.
take place in the tribunal.
Lordship,
This is how the proceedings take place in the tribunal. If you don't give training, there's no point having a foreigners tribunal. If the government does not want to train train them, the foreigners tribunal. You come to page 30,
yes, Lordship.
page 30, exhibit 1, signed by the member. Down below it is written exhibited by Sikandar Yunus Ali advocate. Advocate was never examined as witness. If this is how you permit.
Lordship, page 31.
Maintaining the tribunal only for media, that we are trying to do something. There's no intention of the government to do anything concrete. And once it is marked, entered in the judgment, you can't do anything about it. But Mr. Ahmed, this document is not exhibited. Page 59.
39.
Dismissing it then.
39 is not exhibit.
No, then we have no option but to dismiss it.
The 39 is not, Lordship, the others border list, Lordship. The
No, but please
page
connect it.
68, Lordship, the border
Mr.
list of 2008.
Mr. Ahmed, you have read case laws on the point. Please try to connect your voters list from your lineage, from the parentage. Please do it. Do that. Just show us that this is the document. This is the link document, showing and correcting me as a son of your father. Just show us. You know the law.
In the
I'm taking
2000,
up only for last 3 days. We are taking for last 3 days. We are doing it for so many years. You must be more equipped than we.
Lordship, the 2008 border list, also my name is there, my against my name, father's name is, dear lordship, was exhibited lordship,
That was discarded.
exhibited 5 lordship.
But that was discarded. The reason is assigned there, why it was discarded. How do you overcome that?
Documents were exhibited lordships,
No, that we understand. But this document was discarded. It just shows that this opinion was wrong.
the petitioner claim lordship, his father's name is Amesh lordship. And against his
No.
name, Amesh is
Sir,
dear lordship.
We are repeating it for the third time. In the opinion of the tribunal, this was discarded. This shows that this opinion was wrong. That is the only thing you have to do. What is the ground on basis of which you say that this opinion is wrong? You should tell us that only one line.
The in the judgment lordship, the no linkage was with my father's.
Correct.
But
So shows
the
that it is
lordship,
wrong.
in the voter list lordship, the 85, 90,
Voter list, you see,
97
voter list is not a proof. You must link that voter list to some document which connects you to as a son of your father. Where is that document? The court is discarded. The tribunal is
The
discarded
document was not proof lordship, but the exhibited lordship. The one chance to prove the documents lordship.
Hmm?
Prove the documents lordship to remand back.
We are accepting it. Once the tribunal has recorded it in this judgment as exhibit, we are taking it that you have exhibited that. But where is the document?
This is the public documents lordship, the voter list lordship.
That is a proof of father.
The lordship.
It shows a judgment which says that the entry in the voter list is the proof of parentage or sonship. Any judgment which says that entry in the voters list is a proof of parentage or sonship. Where is that?
1 week's time lordship, some.
No. If you want to take a judgment, take it before you open up the file.
Okay, for dismissal. Page number 16, below, summary. Number 3, who is sending in and not coming. Some reasoning. Why they come in, he is not convinced. For these documents, we not. The paragraph 4 is pertaining to post cutoff date. But yeah, some deposition is necessary.
We are adjourning it, that this, we are making this clear to all the learned counsel. If you have to take adjournment, take the adjournment at the first blush. Don't make us open the file and then waste our time. We already have more than 10,000 matters of this Foreigners Tribunal. Because once you see, Mr. Ahmed,
Lordship.
most of the complaints we receive here from the lawyers practicing in the trial court is that the magistrates keep their mouth shut. They hear the counsel and then they dismiss the matter, and then they say that we did not get an opportunity of addressing. The court did not ask us any question. So we'll have to do the same thing. We hear you don't express ourselves, and then you know how we'll dismiss it. Would you like the first one or the second one? You want an interactive judge or you want us to be non-interactive? We can be both.
Lordship, I claim that my father's name is.
No, no, we're
Ames,
asking a
Lordship.
specific question. How do you want us to be in the court? You want this particular bench to be interactive bench, ask questions, or you want us not to be interactive? What is the requirement you have of us?
No,
What is the ideal way of you looking at us?
no, Lordship.
No, you don't want to look at us.
Lordship.
Good.
Lordship, I claim my father's name is Ames. In this regards, the opposite sides no raised any question.
No, this is not required to be given. You have read Surveillance Sonwar number 1.
Lordship.
What does it say? It says that the father's parentage has to be proved. So why somebody will ask you a question? It is your requirement to prove it. Burden is onus is on you.
Lordship, in the page 18, Lordship, the family data is there in the WS.
Huh?
Family data, Lordship. So my only
That is-
one
that is
brother, he
not
was
proof.
examined.
That is not a proof. That is not a proof.
You'll have to prove it.
This is the fault, Lordship. One son's Lordship.
You see, let me tell you. A comes and tells us that he is the son of the King of England.
Is the proof.
He gives us a letter that he is the son of King of England, and then comes here and tells us that, well, I am the son of King of England. I have never heard his name. His name is not documented in the any annals of history. And then he gives a declaration, files an affidavit saying that I am the son of King of England. So what I'll do, I'll treat him as a crown prince.
Lordship, the documents is submitted, Lordship, then the said documents was exhibited. Lordship, in the reflect in the judgment, Lordship. Also.
How does it link you with your father? On what basis? In the voter list, you are not there. Subsequent, there is no reference to your father.
My brother was examined, Lordship, so he claimed.
He
How
also
did you
failed to
link-
establish his
No,
thing.
how have you
to his
linked your
position.
brother to your father? It's just
Mr.
a mere
Ahmed.
statement.
Mr. Ahmed, don't test our patience.
Lordship, one
Don't
time
test our
to
patience.
for instruction, Lordship.
But we are telling all the learned counsel, if you want to take an adjournment, take it at the first batch. If you make us open the file, and then you have to complete it, because then we'll start dismissing. Every time we can't be lenient like that. Waste time, half an hour time, and then say adjourn.
On Monday, Lordship.
Okay. But next time, don't do it.
Lordship.
You are praying for 1 week's time or on Monday?
1 week's time, Lordship.
Then you said Monday.
Next week, any date, Lordship.
Mr. Ahmed, remember, we don't forget so easily. All sides are represented on the prayer made by the counsel for the petitioner. This after a week.
Diploma.
Yes, item 8.
Respondent number 1 and 2 were directed to file affidavits. I have served them extra copies, my lord. This is a unique case, my lord. The petitioner's parents were from Afghanistan, border area of Afghanistan, my lord, in the year 1949. So learned tribunal below said that the tribunal do not have any jurisdiction, as because they
Where
do
is-
not come from specified territory, my lord. Otherwise, everything is okay, my lord. Since 47, 48, my lord, his father was came to India, my lord. Thereafter, they are staying here in the Sibsagar, my lord, and adopted Assamese culture and everything, my lord. All of a sudden, since 2005, my lord, they were shown as D voters, my lord. The matter was referred to the tribunal, and tribunal, after examining the witnesses, held that they do not come from specified territory, and that is why, for lack of jurisdiction, the case was dismissed. Otherwise, no problem, my lord.
Where is the opinion?
Why is it
24.
impugn order?
Huh?
24.
My lord,
Impugn order, 20?
impugn order, page 22, my lord, and it's
24
Three
is the
matter.
ground.
Lordship may come to page 24, my lord, paragraph 8. I have perusal of the records and documents exhibited and proved by the opposite party. I have also perusal the verification office report. After perusal, it appears that the opposite party, Sultan Khan, is
You are declared as the voter.
devoter. Thereafter, matter was referred, my lord, and Lordship may kindly see, and according to the verification report, opposite party but mentioned as casually, the opposite party studied from so and so, and they could not, content could not be proved. Hence, the case is not maintainable by this tribunal, my lord. Lordship may kindly to page 24, the upper portion, my lord. The second paragraph.
1 minute,
according-
1 minute. Just one.
According to section 6A, my lord.
Just wait.
No, we can't do it, but we will agree with the D voter. No, he is identified as a D voter.
Lord,
Ms. Gahan and Mr. Payang. In this case, rightly or wrongly, there is a reference made to the Foreigners Tribunal.
Yes.
Foreigners Tribunal heard the matter on merit. DWs were examined. And then it gives an opinion that it does not have jurisdiction. Now, I think we have a judgment of this court saying that the writ court cannot transfer of proceedings under the Foreigners Act.
Yes.
Correct?
Yes.
We can't do it. Now, your what you call your tribunal does not close it and tell the SP border to present it before the appropriate tribunal. Correct? That's one part. There's a fallout of that. The fallout is that after a trial, there cannot be a retrial
Yes.
unless you show so because neither a civil proceeding nor a criminal proceeding can be retried. So under that circumstances, what do you, what is your stand? Because affidavits have not been filed, that means there's neither the state government nor the central
Okay.
government has any stand.
My lord, in this case, my lord, we have already sent a letter to the Union of India, my lord, for an instruction, but that is still waiting, my lord. Sometime maybe so that we can file the affidavit to our stand. We have already communicated to.
When did you send the letter?
But, as Purva sent, earlier actually, my lord, that case is dealt by the Simantani Borua. She informed me that she sent in Simantani Borua, CDC.
Okay, it's okay,
He-
but
she
when,
sent a letter.
when did,
Yeah.
when,
May I take the instruction from her, my lord, when he sent the letter?
because when it was sent,
Yes, my lord. Just,
Till the date.
yes.
no, it's okay, he or she must be in the court. We don't want to disturb them right now.
No, she is actually to some medical emergency. She
No,
is not at.
don't make him worry at this point of time.
The power to decide in relation to specific, about specific territory.
Because Mrs. Dan and to you also, Mr. Pang, you see, my brother has rightly pointed out, insofar as the people of Nepali origin are concerned,
Yes.
you have certain arrangements, correct, to the Ministry of External Affairs. Now, for people who have entered the country from this, not from the specified territory, question of affidavit will not serve the purpose. It's a question of law. If you have any alternative way to prosecute them, you'll have to tell us, taking instructions. If there's any other tribunal constituted to deal with those, it is the call of the government to make the transfer if the court does not do anything. The only question now is that in the absence of any information to the court as to whether there is a tribunal or some arrangement made by the central government to deal with issues like this, the tag of devoter has to be removed.
What my understanding, man. That if you go through the law of this, my lord,
Pardon me?
the law provided by provides, my lord. First of all, my lord, initially the tribunal has the authority, they have taken the jurisdiction, my lord. But, my lord, only from the judgment of the, my lord, there's, in case of that, my lord, yes. Indira
You
Nagar
see,
case, there
Mr.
was a,
Pang, that is why we told, in the
Yes.
last matter we told,
yes,
it is for the government to
Take it.
to give them training. You see, if it was a civil court, then we know that if the court does not have jurisdiction, the plaint is returned.
yes.
In this case, the opening, the application was not returned. It just court says I don't have the jurisdiction. Now,
After the trial.
after the trial. So after the trial, who has the power and authority to transfer? Nobody.
But then in that case, my lord, the tribunal, the state, central government, neither the central government nor the state government has any other, my lord, tribunal for that purpose. It is the
Real
executive authority,
You can give it, you can pass orders under 3 capital A.
yes. Well, yes, 3 capital A of the Foreigners Act, directly it can be passed. Or, my lord, in case of Assam, expulsion of Assam's immigrants from Assam Act 1950 may apply. Because that act is still prevailing, my lord. That act has not been repealed. So it is prevailing. So, my lord, what my submission, Sikhs say Because the cases are, those, the tribunals are taking the matters under 6C. Those persons who are coming from East Pakistan. It's a specific privilege given to those persons who has come from East Pakistan and who are Indian origin, originally Indian, and who has come from East Pakistan. So it's a privilege given to them. Privilege given to them. This privilege will not get by any other person from any other country. So if he is coming from Bhutan, he is coming from in fact, in Rohingya also, they will not have, in that case, the foreigners tribunal order 1964 will not apply, because this is only for the 6A. 6A will cover only the East Pakistan people, those who are originated from India and Afghanistan, other part of the world. If he comes from Pakistan also, he will have to cover under for illegal expulsion of illegal immigrants from Assam 1950. So in that case, there is no tribunal. The police authority, they can take him and they can deport him by an executive order.
And here you can't do anything.
Yes.
After the trial court says that we don't have jurisdiction, so therefore there is
Yes,
no opinion.
Tribunal has no jurisdiction. Tribunal has
No, not that. The tribunal has not given its opinion that he is a foreigner.
Yes, yes.
How can you deport someone? How can you now presume, when the tribunal has not given an opinion, can the government now presume after the now recent Supreme Court judgment to pick up anyone and say that you are a foreigner?
That is,
On the contrary, my lord, the instructions were given to take necessary actions to the authorities, directed to take necessary actions by the
in fact, the
authorities.
tribunal ought not
What
have
actions
to
you will take, my lord?
the tribunal ought not have go for trial, if he has seen that
No, because you see, that happens because the people who are your representatives before the tribunal did not assist the court.
My lord, he was
Nobody pointed out.
wrongly, my lord.
We allow the
trial
trial
order
to proceed and the tribunal then comes to a finding that we don't have jurisdiction.
without any grounds, matter was referred, my lord. Without any grounds, my lord. My father is staying here from 48, 49 after the partition, my lord. I have all the documents, my lord. Only thing is that they have not applied for citizenship as per the constitution, my lord. Article 527, my lord.
What about section 15 of the Citizenship Act? Have a look at section 15. Yes. Provision for revision.
Revision, any person aggrieved by an order made under this act by the prescribed authority or any officer or other authority or other than the central government may within a period of 30 days from the date of the order make up an application to the central government for revision of that order, provided that the central government may entertain the application after the expiry of the said period of 30 days if it is satisfied that the applicant was prevented by sufficient cause from making an application at that time. On receipt of any such application under subsection 1, the central government shall, after considering the
Just a moment.
There is a registration. 6 is naturalization. OCI. Naturalization. Application.
What according to you is the date of birth of the petitioner?
He's 75, my lord. 74, 70.
Is 1971.
71.
What is the document of your father entering into India in 1940?
Yes, sir. Worship may come to annexure 4, my lord.
Page.
Page 25, my lord. This is an affidavit, my lord. In the year 1962, my lord. Before the magistrate Shivsagar, Muhammad Nabi, son of so and so, that I came to Hindustan about 13 years ago. It is 60 to 52, prior to 50, my lord. Around 48, 49, to live and to do business in Union with no intention of going back to my native community of in Gulab Khan in Palpunistan. And since then, I am living and doing business in different places of Indian territory. That I desire to be a citizen of India. This is true to my knowledge. Statements are correct, my lord. So this is the affidavit. Then your lordship will find next page.
Just a moment.
Was he declared a citizen? No.
Just at that point of time, he used to, no, he was not declared. He is not applied, my lord, actually. I have sought his instruction. And he said that what my father done, I don't know. So things were going on like that. And all of a sudden, my lord, they realized that they have a notice from the tribunal where reference has been made without any grounds, my lord.
Where is the reference?
The reference,
here?
my lord, you also will find at page.
You have the
annexure 1,
original of
page
this,
16,
page 25?
Page 25.
Do you have the original of this
Yes, yes, yes.
to us?
My lord, right now, in the custody of my lord. If your lordship insists, I can next day bring in all the documents, my lord, in original. Because these are vital documents they took back, my lord. Lordship was asking for the referral, my lord, lordship answered. Annexure 1, my lord. Annexure 1, page 16, my lord. Lordship will find in the page number 17, my lord, next page, grounds for having reasonable doubt that the person concerned is illegal. No, nothing, my lord, as referred by ERC, just doubt, casting doubt, no, nothing else. They should have verified everything, my lord. Since independence, they are staying here, my lord. As many as, my lord, 17 documents I have exhibited, my lord, both from my father's side, mother's side. All are established businessmen, my lord. Sonitpur, okay. Because, my lord, my future generations are being affected, my lord. If I am shown as D voter, my son, my wife, everything. Otherwise, I ought not have also challenged this order of the. And my lord, may come to page 27, my lord. Annexure 5. My father is contributing fund, Pashtunistan fund, my lord. In the year 56, my lord. From Jorhat, Assam, my lord. Thereafter, Annexure 6, my lord, page 28. Certificate, my lord. This certificate, my lord, tribunal is saying that it has not been proved by the issuing authority. One of the lines she is giving, my lord, without any reason, my lord. If the tribunal is saying
You
that.
see,
no
this affidavit doesn't help us in any way. This
but
page
at least,
25
my lord, it
affidavit.
is a document, my lord. It's an affidavit, my lord. I
No,
can produce
because
the
because
certificate.
in its contents, it says that you wanted to be a citizen of India. So who prevented your father from applying for
that-
citizenship?
That I agree, my lord. I don't know because.
See, if-
But
if
fact of the
it's-
matter, my lord, I have been staying here.
No, you see, you don't fall within
And
the.
I will then, my lord, I will apply for appropriate, my lord, to the authority, my lord, with all my documents.
Where were you born?
My lord, I am born in the Dhekejuli itself. my lord. I am born and brought up by birth, I am here.
Section 3. Honor legal. Honor after. Honor after. On or after 26th of January 1915. But before.
69 or Dhekejuli.
I am.
My lord.
Please tell us two things. You have a copy of the Citizenship Act.
Yes, my lord.
Please come to section 3,
Yes.
3(1)(a). If someone is born before 1st day of July 1987, he is a citizen of India.
Yes.
Now, where do we find any provision in this act for them to apply for citizenship?
I think, my lord, it BC code maybe.
Citizenship by registration is there, section 5, my lord.
No.
Section 3(1)(a)
3(1)(a)
does not need a registration.
Yes.
Or not after the 26th.
If you
Born
born
is
before
not
87,
for
you are a citizen. That's the mandate of the act.
You see, there's only one issue pending since 1950, what you call, 2015, before the Supreme Court of India, you know that.
Yes.
One issue is pending. That has not yet been decided. Even yesterday I tried to check up, I did not get it. Writ petition civil 1.5 something.
But what my understanding is, and from the present, the order of the tribunal, my lord, when initially he took up the tribunal, took up the matter as being because it was referred to him to the tribunal. Tribunal took up the matter. On evidence, it is found that he is not from specific territory. So he said that I have no jurisdiction. So he sent back a matter to the saying that he is not from a specific
He
territory.
did not send back. Did he send back?
Yes. They send back the referral authority for necessary.
No, hence the case is referred to the referral authority.
Yes.
It doesn't say send back or return. If it was
That's
returned, we would not have asked that question.
maintainable by the tribunal. Tribunal has not maintained. Hence, the case is referred to the referral authority for necessary action. Referred back matter, because it was referred to him. He referred back, I have no authority. So whatever authority you have, it is the police, what if they found in an inquiry that he
No,
has.
no, for that we are asking you one question.
Yes, sir.
The question is under the civil procedure code as well as under the criminal procedure code, there can't be a retrial.
There cannot be a trial, but retrial
Correct.
cannot.
So therefore, if you have any provision under this Citizenship Act and rules or under the Foreigners Tribunal Act, Administrative Tribunal Act, whatever be the source of power, if you can say that this way of returning back the reference is something which can be equated to the power of return,
Yes.
then you understand.
It
You
is,
see
but-
here, this is technically asking you, he is assailing this judgment.
Probably he's
Correct.
not assailing, he's
Now,
saying matter on the basis of.
He's
the-
asking
he
for
may be
quashing.
wrong.
He's asking for quashing.
Quashing. Quashing.
My status. Actually, the proper finding of
Time we should show.
trial approach to the trial.
This, they want to. They say that yes, it is the matter. The matter is-
This is a unique case.
Create one.
But in that case, we have no objection if your lordship calls this for the judgment. And then natural procedure.
No question. You see, it's a situation where you don't have an answer.
Yes.
Number one, the petitioner is not seeking
Yeah.
that the reference itself was wrong. He says quash it. Quashment can't be done because of the fact that we by quashing it, we can't say that the tribunal had jurisdiction.
Yes, madam. So if we
See,
are not, we will not say
if there is
anything
no
about it.
jurisdiction, we can't confer jurisdiction. At least the Red Court can't confer jurisdiction.
Yes.
So question of quashing does not arise. You'll have to dismiss the writ petition. But what happens, the query is only on the applicability of section 3, that the petitioner is not making a prayer. So consideration of the court on the section 3 is also unwarranted. Because otherwise we'll try to make out a case where there is none. We are just trying to understand the provision of law, because if section 3 says, because since yesterday this is coming to us, the lot of arguments we have seen since the last 3 days on people who have been born before 1987. So that is why we are just trying to have an answer. If he is born before 1987, then the
No, no, there can be.
question of law takes its own course.
two provision, because if he's asking for this specific, matter in this case, it may be applicable. Because in other case, matter, there is a special provision 6A. In that case,
60 does not, 6 does not say, does not exclude section 3,
yes,
P1.
but it is a
A.
special provision given to some other
You
person.
see that You see that we'll take a break and come back.
Yes.
It just shows from this 6A that
But,
application of 31A is excluded.
But that point we'll take up in some other matter if your lordship heard it properly. But in this case, because there are some issues, my lord, under section 3A. If he claims by birth, that has to be established by a strict proof, my lord. It has to be proved by a strict manner that he is born in India on this particular day. That has to be established. That specific claim should be there, that has to be established.
He's born in, that's what he's claiming. He's
No,
born in India.
I'm not on that in this case, my lord,
Yeah.
on other case, but here, my lord, in fact, he has been given, my lord, by this order, he is benefited. But only his problem is that his name has been marked as D. So he could come before this honorable court against D, that my D name may be removed, as there is the references, my lord, are negated.
If that observation is given, then I am safe, my lord.
No, but he has, my lord, challenged the order of the tribunal.
Because it's a vague order, no? What action FIL authority will take?
My lord, because as per if, my lord, the rule is that during the time of, my lord, Afghanistan, those persons who used to come to Afghanistan, they were allowed to stay here by giving a, my lord, authority letter from the SP. SP used to give for 1 year to stay in state of Assam. It was renewed year by year. That was the process. That is the process, in fact, today also followed. But probably there is a central government notification to that effect. On the basis of that, they are allowed to stay here. Like, my lord, those Nepalese who has come from, my lord, Nepal, even though they are not citizen, they are not citizen, they cannot be deported.
No, that is because of the central government.
Yes,
notification.
Indo-Nepal Treaty.
Hmm.
Indo-Nepal Treaty is there.
So is there anything like that for citizens from Afghanistan?
Probably there is. Otherwise, how can, my lord, I don't know, how can the SP issue an order that he can stay for 1 year? The SP used to stay, my lord, issue some orders for staying them for 1 year. And this is renewed year by year. This is the procedure followed, what I have seen, madam.
Because you see the state never questioned the correctness of Exhibit 4.
Yes.
That is the identity card where the petitioner's father had disclosed himself to be a person from Afghanistan.
Yes, my lord, that's why I'm saying a person from Afghanistan were allowed to stay here in India, my lord. But the SP used to issue certificate that he give a certificate, he can allow for, he can stay for 1 year.
Don't speak when somebody is addressing the court.
My lord, he can stay for 1 year. This kind of certificates are issued by SP. My lord, this is admitted position. The Afghanistan, there are numbers of Afghanistan people, all those, my lord, Afghanistan who used to do business of this money lending, they are having this kind of, my lord, order from the SPs, and they're staying here. But they're not citizen. I don't know whether there is any notification of the central government or not.
My lord, may I call RKW? I think there was a case, similar case of Afghanistan, my lord. He dealt by that RKW. So may I call him, my lord?
Yes, after.
After break, my lord.
You'll-
Because we're just thinking aloud. Now, what happens if the petitioner withdraws this and come with a fresh writ petition saying that there is no reference has been returned, there is no reference and therefore D-voter tax should be removed, then what happens?
I have seen, my lord, in SPs, they used to issue certificates to the, my lord, Afghanistan people. They are given 1 year of the presidential permit for the SP. That's why I asked my get the instruction. If in central government has any such thing. If father continuously, father is a foreigner and he is residing in India, then by birth he may not get. Because the father cannot have when citizenship is not permissible. Then if he is become Indian, then only.
P1A does not say so. P1A says any person who is born in India. It doesn't give a qualification or a rider saying that XYZ will be excluded. Whose father is a non-citizen will be excluded. That prescription is not there. But that prescription is there for the other provision under 3.2. So that provision is there. So therefore, we will have to presume that the legislature is aware what they are doing. Not even a word of the legislature is useless. So they have omitted to do for a certain reason. Therefore, if somebody is born in the territory of India, he becomes a citizen of India. So it's a question of law because the affidavits will not be no government officer will give you an affidavit. If there is no policy, he will not give an affidavit. So we take it up next week. August first week. Okay. All sides are duly represented. On the prayer made by Ms. A. Gayan at CGC. This is the matter in the week commencing 5/8/2024.
Whether 7 or 8. Because that I have contacted because of my phone education.
Okay, on 7/8/2024, so it's unable to obtain instructions.
Item 9.
Yes, Mr. Rahman.
My lord, the impugn order is at page 17, my lord. In one, my lord, the final order declared on my lord 6/3/2023, my lord.
Where is your written statement?
At page, my lord, 45. Annexa 2, my lord, page 45.
And where is the opinion?
At page, my lord, you come to page, my lord,
Opinion starts from 17.
50, my lord, page 36, para 52, my lord.
No, where is the opinion?
Opinion is at page, my lord, 18.
What is wrong in this opinion?
My lord, I have, my lord, annex. The voters list 66, my grandfather, my lord. And my lord, 40% from my lord, para 52, my lord. Para 52, my lord. Page 36.
Page?
Page 36, my lord.
Yes. Yes. So Panchayat certificate was not proved through by calling the Panchayat people.
My lord. And there, then you'll also come to page, my lord, 55.
Page,
Sorry, my lord, page 37, para 55, my lord. My mother, my lord, deposed, my lord, as a DW2, my lord. Setaran Bea, my lord. Your lordship now come to para 70, my lord, page 42, my lord. I have shown the link documents of my grandfather, my mother, my lord.
but Mr. Rahman, the tribunal rejected it based on the cross-examination of your mother.
My lord.
The mother does not know about the lineage of your father. So if your mother does not know about the lineage of your father, then what is wrong in the opinion?
My lord, can you see page 42, my lord, para 70?
Page 40,
42, my lord,
42.
para 70, my lord.
Yes.
Now 71, my lord, resulted in terms of the above analysis, does question arises as to whether the purported voter list of 1966 and 70, exhibit 1 and 2 by CHEP should be accepted as sufficient proof of existence, or his claim without proof of linkage with her projected parents and grandparents by cause and reliable evidence that her projected grandparents and father names were enrolled prior to the cutoff date of 25/3/1971, as stipulated under Section 6A of Citizenship Act 1955. Answer to this question would necessarily be in the negative. I've shown them, my lord, the link document, my lord.
Is there any voters list showing your grandfathers and your father together?
At page, my lord. At page 76, my lord.
Page
76,
76.
my lord.
Yes, page 76.
Yes, my lord. Tushar Ali, my lord. My father, my lord.
Tushar Ali.
My lord. And Rahman Ali, my grandfather, my lord.
And then where is your voters list?
At page 82, my lord. Page 82.
What is your name?
My lord.
Sora Khatun.
Surah Khatun, my lord.
Sora Khatun is not here.
Tushar Ali, my lord. My father is there at page 85, my lord.
Tushar Ali is your father.
my lord, my father.
Where is the document to link you to your father?
That is at my lord, there is a link, my link 95, my lord. My mother, 95 page 95, Siratan Bidra and Tosarli.
Page 95.
Yes, my lord.
No, these are all independent. Unless you have it together,
Yes, my lord.
how do you understand it?
My lord, at page 100, my lord. To whom it may concern, given a certificate, my lord. At page 100.
No, this was rejected because the panchayat people did not come. This was not proved through the panchayat representative.
100 and 102, my lord, page 102. And 103, my lordship, kindly see. This is certificate Sora Khatun, daughter of late Tusar Ali, and inhabitant of village Kasumara. She is living in the area. I know her well, my lord. Then, my lord, village headman certificate 104, my lord.
No, but these were not proved by the authorities. These people, the authorities who issued this, Gaon Panchayat, their representative did not prove it. We have so many judgments saying that it can't be proved through another authority. X is giving a certificate, Y cannot prove it. You see, Mr. Rahman, please come to this page 104, for example.
My lord.
So this is a certificate saying so and so, correct?
My lord.
Now, please tell us what according to you is a certificate.
Village headman certificate, my lord.
No, I understand, but what according to you is a certificate? Certificate must be something which is an extract of some record. Now you have to tell us that the panchayat is required to maintain all these details.
Then, my lord, my written statement.
No, complete one part and then come to another. You see, to be a certificate,
My lord.
like for example, my metric certificate which I have. I gave an exam. I have a proof of that because I have a
I got
admit card.
my lord.
And then I sat in the exam and got a particular percentage. For that, the SEBA gives me a certificate. And that is backed by my answer scripts, which was there, and therefore they gave me a certificate of the marks obtained. So it is a record. It's a certificate of a record which is available. Now, if that record is not available, it becomes a personal information.
My lord.
So once you are showing us a panchayat certificate, you have to also show us. You have to presume that we don't know what is the panchayat record, and therefore you have to show us that the panchayat does maintain this record of the family members. Who is the wife of A, who is the son of B, who is the father of A. All those records they are required to maintain.
Panchayat, my lord, actually, Panchayat office, my lord, they did not keep any record of that, my lord.
So if that is not there, this certificate itself does not have any evidentiary value.
But in the written statement, my lord, if your lordship turn to page 46,
Yes.
there are 10, my lord. There are 10 and 11, my lord.
Yes.
The second person's name, Sora Khan, alias Sahara Khatun, father's name, Tosar Ali. Rahman's name appear in NRC details, 1951, legacy data number so and so. Is it about 4 years, house number so and so. Then, my lord, next para. The second was a grandfather, namely Rahman Ali, son of Gomar, aged about 48. Grandmother, namely Posam Nessa, wife of Rahman Ali, is
No,
it
sir,
about?
Ahmad, this is the same
It's
question
not-
which I was putting in the, in one matter before this.
And my lord,
You see, this is a declaration. Sarvanan Sonwar says, what is that paragraph? Sarvanan Sonwar, 113,
16.
116,
or
Huh?
26.
26 of Sarvanan Sonwar 1. So that paragraph says that the burden of proof lies on the proceedee to show that he is a son or daughter of someone. So mere statement is not a proof.
my lord, that DW1 also, my lord, 2 also, my lord, depose.
Who is DW1?
DW, it's me, my lord, and 2, my lord, my mother, my lord, at page 63, my lord. Can you see para 3, my lord, page 63?
No, this your mother. That's why you see you have shown us a one of the voters list. It's an independent voter list of only one entry.
My lord.
The family members' entry is not there.
My lord.
If she's your mother, your name will be recorded along with your mother or any other siblings with your father, and then you show that family tree. In the first page of your pre-page of your writ petition, you have given a chart.
My lord.
So there must be some people who are there in the voters list along with each other, so as to we only want to see the lineage. If you can demonstrate that the lineage is there, you have made out a case. You see, you have filed 29 documents.
My lord.
So in these 29 documents, you have to just place one document which links you with your parentage.
My lord, the Panchayat certificate and village settlement certificate, my lord.
That has not been examined. It has not been proved. What is the value?
Then, my
Mr.
lord,
Rahman.
I have no more option, my lord. Your lord may declare foreigner, my lord. I have no other option.
He can't declare foreigner.
We
It has
can't
already
declare.
been declared foreigner by the tribunal.
We can only dismiss the petition.
My lord.
We can't
I have
declare
no other
anything.
option, my lord.
We'll call for the record, let us examine how they have dealt with the matter.
My only fault, my lord, the president and secretary was not examined, my lord. That's my only fault, my lord. Otherwise, every link document, my lord, I have submitted.
No, we don't know. You see, you are all seasoned counsel. You can have your training course. You can have skill upgradation. And this is, you see, we've been, I've been off and on associated with this bench in two previous determinations. We all see that there's we only note that there's a pattern. Advocate A will come with foreigners cases of a particular district. Advocate B will come with a particular district. Correct. When we ask for certain particulars, you will say that I am not in direct contact with the council. Let me have the interaction with the council to get the records. Therefore, everything appears to be channelized. Correct.
My lord.
Now, if you have this district-wise or area-wise or town-wise association, why you can't upgrade the skills? You are hearing us every day. We have till date pronounced, I think, more than 1,000 judgments. Why can't you upgrade your skill?
My lord, in this case, my lord, I have submitted, probably it is a record at the 7th Barbados Tribunal, my lord. 39 documents I have submitted. Only, my lord, my fault was, I didn't examine the
It's not a
Panchayat
question of
secretary.
fault. It's a question of misapplication.
That's why, my
You
lord.
see, we are asking you a question right now. You tell us that the panchayat has a duty to keep a record of who is the son of whom, who is the father of whom, who is the brother of whom. If that is the duty prescribed,
But he's
we accept it.
my lord, he's a good man. He's a good man, my lord. He knows the Panchayat secretary and
No,
president
no,
knows,
no.
my lord, who
That means it's a personal
who is
knowledge.
here, whose daughter, they
No,
know, my
no.
lord.
When he is giving us certificate,
in a
he
better
is
position
issuing a
to, my
personal
lord.
knowledge. He
Because
can't
that
use
was
the
happened.
pad of the panchayat. You're a good man, you give your certificate, give the certificate to Prince Charles.
Generally, my lord, they'll
He's
never do it, my lord.
he's the son
Outside
of Queen
jurisdiction, my
Elizabeth.
lord, outside jurisdiction, they will not do it, my lord. Within
see,
their jurisdiction, within only their
Mr.
place,
Rahman,
my lord.
I'm asking you something. You see, what is the value of your certificate to Prince Charles saying that he is the son of Queen Elizabeth?
Correct, my lord.
Correct. That certificate has no value. So a personal certificate can't be issued in a
My
letterpad
lord,
of the
can it be, my
panchayat.
lord, can it be, my lord, remanded back to, my lord, so that, my lord, I
No,
can,
no,
my lord,
It's not so easy.
I can, my lord,
You have to set aside the opinion. We can't remand it back like that. We'll have to set aside. To set aside, we must come to a finding that there is some fault or defect or the opinion is perverse. On that, you have to argue. We can't just set it aside to give you a further opportunity to.
my lord, then on Monday, my lord.
No, no. We will call for the records. You
Malad,
get
malad.
sufficient time. You should.
Mr. SSS Rahman, counsel for the petitioner, Mr. J. Pang, learned standing counsel for the Home Department, Ms. P. Barwa, standing counsel for the respondent number 6, and you're appealing for respondent number 4. And this, sorry, I'm forgetful here. Mr. S.K. Hazarika, learned standing counsel for number 4, and Ms. A. Gayan, learned CCA for the respondent number 1.
Not to be arrested and deported. Not to be arrested and deported and yes. We intend to peruse the trial court records of the foreigners, foreigners tribunal number 7, Bobeta, before admission. So accordingly, that these said records be called for. Next para. As the petitioner has assailed the impugn opinion dated 6/3/2023 passed by the Foreigners Tribunal 7th of Bogota. In FT 7th Bopeta, case number 126 of 2018. The court is inclined to provide that that
My lord, there is another,
till
my
the
lord.
till the next returnable date. Did for the orders, the petition shall not be, the petitioner namely Sora Khatun alias Zahra Khatun, page 2 of the writ petition, shall not be arrested and deported from India Next para. The petitioner shall appear before the, this part of the order, take it from my secretary, huh? The petitioner shall appear before the SP border, which place, Borpeta,
Borpeta, my lord.
and within a period of 10 days from the date of the order, and shall take a bail of a sum of rupees 5,000. This part you take it from there, and iris and all that will be there. Huh? So you take the iris and the fingerprints, huh? Bail bond, those things. Biometrics and all, huh? It will be, you take it from there. Post of, let the matter be listed. After 4 weeks awaiting visit of trial court records. Acha, just before that you say, in the meanwhile, extra copies of the petition will be served on the learned CGC, state and the learned departmental council in course of the, within 2 days.
Item 10,
May I please, Lordship? It is a contested matter, Lordship. Petitioner has been declared as a foreigner, Lordship. The petitioner has exhibited a voter list of 1966, Lordship, that is page 26 of this petition. Sorry. Page 20 of this petition, Lordship, where the name of the grandmother and uncle have been appeared, Lordship, serial number 31 and 32. Then, Lordship, voter list of 1971, where only another grand.
Just a moment. Serial 31 is your grandmother.
Yes, Lordship.
Yes.
But in the voter list of 1971, Lordship, the another uncle of the petitioner appeared, that is named Hazrat Ali, Lordship. And in the voter list of 1985, the petitioner father's name appears for the first time, Lordship, serial number 726, Marjat Ali.
Where is your name?
My lord, Kabin Nama, Lordship. Yes.
No, not in any voter list.
Yes, Lordship, but there is, but I have not annexed, Lordship. Statement is there, Lordship.
Did you ever get time to read the Evidence Act?
Lordship.
Did you ever get time to read the Evidence Act? You don't get time to read Evidence Act. So a document which is a fact which is recorded in form of a document. Can you give a statement which would be acceptable to the court? You are looking us at in a way that for the first time you have heard about Evidence Act. First time you have heard about Evidence Act?
No,
No. Okay. So don't look blank. What is the fun in making a statement when documents are available? You don't annex a document.
Lordship, the petitioner could not connect, Lordship. So I have a.
But then how do you connect? How do you connect yourself with the with any of the persons, your grandfather, your grandmother? How do you connect? When
Lordship,
there is no document.
I have annexed, Lordship, Brutalist 1966, Lordship, 1970 or 1985, 1989, Lordship.
No, but your voter list is where? Your name is Morjina Khatun.
Yes, Lordship.
Morjina Khatun, which is the document, which is your voter list? Where is the voters list of Marjina Khatun? You are reading the brief now. The Learned Counsel for the petitioner is not prepared with this brief. Accordingly, matter stands adjourned today. This will be next week. Published. We'll resume after lunch.